All right, good morning. We are back in Senate Judiciary. Still on F12. We have Judge Zoe here to provide some additional testimony regarding the draft that we have before us and some of the changes that's made. So, Judge Zoe, the floor is yours.
Good morning. Tom Zone, Chief Superior Judge. I believe it is draft. Make sure I have the right one. 1.1 of 2.6 of 25.
No, we have draft 2.2, February 14th.
That one I don't have in front of me. I looked early this morning to see if there was an updated one. All right, give me 1 second. All right, I have it up. So I'll run through it. A number of the changes are policy changes since the first draft that I testified on. And down to the sections that I had comments about. Page 27. Subsections 10 and 11 deal with records for the Department of Children and Families as well as Adult Protective Services. I think there could be some questions as to whether or not these sections, whether the materials held by those entities should be sealed, and I read the intent that they are not sealed, and would suggest that perhaps you consider adding some language where it says on lines 3 and 4, for instance, enforcement affidavits and related references to such information and materials after the comma. You may want to directly come right out and say are not case record as defined at 7601 parenthesis 2 and are considered. In other words, make it quite clear these are not case records. Just come right out and say that, because it seems to be that's what it's suggesting.
Judge, would you mind just emailing Michelle the language that you just suggested?
The only other part of that I would note, it says produced in response to a lawful discovery order. You may just want to say produced in response to a court order. Because it may not be part of discovery, it may be something else that it's up there. So I think just having the court order provides the protection for the documents. It also provides the ability of the court to address things as need to be addressed. One second, let me see. I'll jump ahead to the one topic that I wanted to raise also is where you look at the sealing provisions that were added to deferred sentences. And that would be on page 35.
Just to interject real quick, I wanted to note that we're actually not planning to change anything regarding deferred sentences and planning to just keep them as they are. So folks who complete the deferred sentence will continue to get expunged.
All right. Well, that gets rid of the necessity of the suggested language I was going to have to keep expunged at least for ones prior to July 1st. So, all right. The other topic, I do note that I've heard discussions about super sealing exception 7 when you were looking at that exception for what records could be used for sealed records. That would be on page 26. And I've also heard talk about a model policy, and that, whichever way the legislature goes, that's a policy decision.
So we're not planning to do any sort of super sealing. The question that we have is more so along the lines of whether or not we do a model policy or some form of judicial review when a police officer wants to access a sealed record. I believe the committee is leaning more towards an officer having to reach out to the state's attorney, who will then file a motion that will be presented to a judge to grant access to a sealed record. Similar to how police officer may call after hours to get a search warrant approved by a judge. Thinking of something similar along those lines to access sealed records, and we were hoping to get your thoughts on that.
If there's going to be that type of process, I think it's going to be something that may add work, if you will, but that's okay. That's what we're here for. But if there's going to be that type of process, we really need to spell out what it looks like. For instance, the rules of criminal procedure set forth what the after hours procedures look like. So the judges, there are specific rules that talk about how the after hours rules work, whether it's for search warrants, non-testimonial orders, conditions of release. So if the committee is going to go in that direction, I think there would need to be consideration of what will the rules look like. There also has to be consideration of what are the standards. If we're going to say that judges are going to be reviewing requests, well, what is going to be the standard? And if you look at, for instance, for a search warrant, the court has to find that there's probable cause before it can issue a warrant. And so the court has to analyze it with that. If you look at inquests, the statutes for the inquest don't require that court to find there's probable cause. It just has to be a criminal matter under investigation, and the court may move forward with the inquest. And so I think it would be important for the committee and the legislature to establish clearly what is the court analyzing and what is the standard the court has to apply.
That makes sense.
Those were the comments that I had on the newest draft.
Certainly, there's also the question of petitionless sealing. Actually, this is Senator Oakesby's questions. I don't want to ask him for it, so put you on the spot.
Absolutely. Well, I was going to do it anyway. So thank you for the invitation. So when we decriminalized and then legalized cannabis, we did petitionless sealing for those crimes that were no longer a crime, meaning that the person in the public didn't have to ask. What is the process for that? And so I am hoping going forward, if we were to decriminalize other things, that we wouldn't have to rely on every member who might have been charged with that, knowing everything happening in this building, but that it would actually move forward with petitionless sealing if it is no longer a crime.
Have you reviewed the report? I had a chance to receive and review the report that I filed on petitionless sealing to the legislature in December. If not,
no, but I am remembering that it exists.
Yeah,
I think that report, I think, sets forth what it would look like and the considerations.
Amazing. Well, then I will not put you on the spot to redo your work. I'll just read your.
I was sitting here going, okay, quick, get the report up and start. But if you have any questions about the report, absolutely happy to address them. But I did consider that, and I had sought the input of stakeholders with respect to what it would look like, what it would take. And if there's any questions on that, I would certainly be happy to appear and answer them. Or if you have any questions outside of the committee on that, please let me know.
If we were to, regarding this judicial review process, taking a few steps back, if we were to follow the standards for an inquest, would that be less work than, like reviewing probable cause or a search warrant?
It would be a standard that is not a high standard at all. It would there are times that judges, myself included, have said no for inquests, but it is a low standard.
Yeah, I would want the standard, given that the point is that they're relatively tightly held and not porous. I would want the standard to be pretty high. So
I guess my question then is, what should the records be used for beyond, what standards should there be beyond it being a legitimate criminal justice purpose?
Just to put the committees, to give you the perspective, under 13 VSA 5131, it says, upon the written application of the state's attorney, a judge of the Superior Court may institute and conduct an inquest upon any criminal matter under investigation by the state's attorney, period. So that says if they're investigating it, we sign it, essentially, but there are, again, exceptions.
So Judge Zoney, being that not that familiar with inquest, when you say it's a low standard, I mean, I'm familiar with preponderance, clear and convincing, and beyond a reasonable doubt. Where does this fall in here?
Below all of them.
Below all of it.
Because this says any matter under investigation, which means if you as a law enforcement officer have someone come up and give you hearsay information and says, I heard that Joe Smith had gone and they did X, Y, or Z, or there's records at the bank that show they've been doing something, financial irregularities, they shouldn't be doing it. And you go to the state's attorney and say, I've heard about Joe Smith, and I looked and I saw he's got some expensive cars. Rumor has it he's got some cash out there that he's spreading around. Now, that doesn't meet probable cause for anything. It doesn't meet any standards. However, the state's attorney may say, well, wait a minute. And again, there's 14 state's attorneys. Some may see it differently, but a state's attorney may say, well, I think that sounds like money laundering. And so they say, we're investigating Joe Smith for money laundering. Hasn't met any of those standards other than we think that there's a basis to start an investigation on potential criminal activity.
So what you're telling me is under an inquest situation, basically the judge doesn't have the ability to say no.
That is not completely accurate insofar as I believe we do have the ability to say no, although I think it is a very limited ability. And if you give me 1 second. I'm not giving an advisory opinion. I am simply stating what I have ruled in the past. I had a request for an inquest. My requirement for an inquest in the court, and I know a number of judges follow this, is that we generally require that there be an affidavit to show that there's some criminal matter under investigation, to get that. In the case that I denied it, I cited the statute, cited some law, and I wrote that the affidavit did not establish facts to indicate that there was any criminal matter under investigation. Rather, it seeks an inquest for use in an employment-related internal investigation. That's not a proper use of the procedure, and the court will not commence an inquest on the information provided. And so I think that if a court looks at it and says this is really not a criminal, you may say that you have a criminal matter under investigation, but the facts don't bear that out. I think a court can decline, and that's why I think the focus is on the word may institute. It doesn't say shall. So I do think there's room there for a judge to exercise appropriate judicial discretion.
Didn't you raise your hand?
If His Honor doesn't mind, Tim Anderson, one of the Department of State's attorneys and sheriffs. So two things. One, remember with an inquest, it's actually, you're asking permission to have a confidential conversation. So you're actually not, the inquest context is a little bit different. But when I've done inquests here in this county, I just wanted to give an example. A person didn't want to talk to the police because of concerns about a certain police officer that was investigating a case. They were comfortable talking with me. And so we had myself, the judge, and the judge's clerk in the room with the witness. And they said, the reason I haven't been cooperating with the police. And so that was the basis for the inquest, right? We had an affidavit. The individual said, I'm not cooperating with police and I'd like to explain why. And we gave them a confidential space to talk about their concerns. And in that case, the judge found that there was a criminal investigation. It was actually an unsolved shooting. It wasn't fatal on a street here in the capital region. And we were able to get to the bottom of it because that investigation was carried out in a manner through the state's attorney, which is sort of an interesting thing. You don't think about us being involved in investigations as much as the police, but it was very helpful and it illustrated to me as a prosecutor, oh, this is why they weren't talking to the police, and they had a legitimate concern about the police officer. And his honor is described everything that I've experienced with inquests. I think could be very helpful in this situation as well, Mr. Chair, because here we have an existing standard that we're already using that we've trained people on criminal justice purposes. And so, for example, the untoward traffic stop where there's no criminal investigation, just taillight out, etc. There's no phishing that can happen because that's not a criminal justice purpose. So the judge would say, look at let's say someone stops someone, taillight out, and they want to search their sealed record, the scary thing we've all been talking about, right? A judge is going to say, that's not a criminal justice purpose. So that would be denied. The access to that sealed record for the use would be denied in this circumstance. I just wanted to point out that there's an existing standard here, and the context that we're talking about is the law enforcement, the police trying to use it for something like, hey, we want to see, as you said, Senator, is there a safety concern here? Does this person have a sealed record for something, right, that might be a concern, right? Anyway, I just wanted to paint that if that's helpful to you all from the perspective that I've had on this. Thank you.
So I continue to sort of be concerned how low that standard is. And I wonder if there is a way to raise that sort of probable cause that the record is relevant to what's going on.
Well, it's certainly that would be a policy decision for whatever standard the legislature wants to impose. When law enforcement is investigating crimes, they often don't have, if you're going to take steps, and Mr. Lueders-Dumont just mentioned, well, if you're on a motor vehicle stop for a speeding ticket and the law enforcement doesn't have anything more, well, we'll call that a fishing expedition if they started asking questions. But a higher standard is there might be a reasonable suspicion based upon things they see that will cause them to take further steps. In the law, there are standards for reasonable suspicion that have been identified, and that's a lower standard than probable cause. And the way the law works is that you are allowed to investigate matters if there's a reasonable suspicion, so that the reasonable suspicion can provide additional evidence that may be able to rise to the level of probable cause that can provide the case to go forward to possibly rise to the level of beyond a reasonable doubt. So I think that reasonable suspicion is something that is already out there for a standard that's higher than an entirely discretionary, let's say reasonable suspicion is higher than the inquest standard, but it's not the standard of probable cause. Because again, probable cause is the result of the investigation. What the release of these materials would be to help law enforcement do their investigation. So I don't think it would be helpful to set that standard that high.
And if I just may, Sheriff Anderson talked about the one time he used it in 20 years was with, there was an individual with a felony record. He wanted to see what that felony record was because the individual had a firearm that was viewable during the stop. And so he found out the person was a prohibited person by doing that sealed record. That was his one utilization of the sealed record access point. So, and I know was that this week, earlier this week? It feels like it was last week, but anyway. Yeah.
So if that were to happen under this, you would have to do the paperwork to get an inquest and call a judge. I
don't know if we would call it an inquest. We would call it an order that would allow for the use of a sealed record. Maybe we'll come up with a better term, Your Honor, but yeah, an access order essentially.
Did you raise your?
Yeah. Would the reasonable suspicion standard still have allowed access in that case?
I don't want to speak to the facts of that one, but it probably, in many instances, it probably would.
Okay,
And there may be, like you said, the major crimes folks may have other context that's
Yeah.
beyond my daily life. But so I want to make sure they have the space to talk to you guys, but I think a lot of the things that we're talking about, reasonable suspicion is, I always think about it as it's the path or the slide or the merging point to eventual probable cause. And as his honor pointed out, that's often where we're at. Like, that's kind of where I was at, honestly, with that inquest that I did for the unsolved shooting incident in this area. It was, hey, I'm trying to figure out, we got some PC, but I felt like I probably had reasonable suspicion, and then I definitely had PC after the inquest. So it helped me connect those jigsaw pieces.
that's helpful. I also appreciate, the point that a sealed record was asked for, once in a 20-year career, to sort of the point earlier that this isn't going to be something that these requests are being made, hundreds of times a day to the judiciary for these access to these sealed records.
And I would note that I think it was in a case called In Re DL at 164 Vermont 223. Justice Dooley wrote about the fact that inquests are not used the way they have historically been used, where you bring witnesses in. In large part, what they become is a mechanism to obtain documentary evidence. And most of the time, what you have are subpoenas. Law enforcement will go to the state's attorney and say, I'm investigating this. I need to get some records. We need phone records, whatever it may be. And the inquest is opened not to hear witness testimony, but to send out a subpoena ducis tecum. And a subpoena ducis tecum is a subpoena that seeks records. And so Justice Dooley wrote about that being the way they have basically been used more than any other way at this time. And I say that because if you may be able to consider, and I don't know what Mr. Lueders-Dumont thinks about this, and I hadn't thought about this until a few moments ago when this was raised by the chair, but you may be able to say that the sealed records could be sought through an inquest. In other words, as opposed to making it an after hours type, quick procedure, it does require more. And I'm not looking to add more paperwork to anyone, or especially the courts, but I'm just putting that out there as that may be a model, and there may actually be it may provide a good impetus to look at our inquest statutes, which could possibly use some updating.
If I may, my only concern with that, with respect, is that my couple of instances of doing the inquest work, it did require court time that I wouldn't want to take away from the daily grind of moving cases. So the expediency of overnight search warrant context, access context, is the fluidity of it. I think with officer safety in mind and victim safety in mind is kind of where I'm thinking, like, that's where we're using it in these examples where it's like, hey, we want to really check here. And so it's clearing out court time for it would be my only flag.
That's what I've been thinking about for the last couple of minutes, regarding the example that Sheriff Anderson provided, while also trying to get at some standard for which people can access sealed records. If Sheriff Anderson pulled that car over in a place where there's no cell reception, no computer reception to access the internet, and we've got a person with a gun in the car, and he can't draft up an inquest or call the judge. Does he just say, well, can't do an inquest, person who might be a felon who had a gun, I guess they're going to go now. So I'm wondering if there is a way to make it so that a sealed record could be accessed under exigent circumstances, and if there are not exigent circumstances, they have to go through an inquest process in which reasonable suspicion is the standard. That's what I'm contemplating in my mind at the moment. Senator Bohos.
I have a question for you. If in that hypothetical you've given, there's no cell service, no internet service, how would you even access the sealed record?
Radio. Dispatch.
So why can't dispatch call the judge to get the information.
Well, the judge is gonna have to talk to the officer who's made the observations, the facts and circumstances surrounding what they're seeing, and they're gonna have to, swear to the truthfulness of what they're saying to the judge. It can't have the cop relaying information over the radio to dispatch saying, hey, dispatch, tell the judge that I think I have X, Y, and Z, and there's also a gun. And then also I swear to it, and then let me know what the judge says. And then the judge talking to the dispatch.
Okay.
I think that could be problematic.
One of the things I think is important from the judicial perspective is the transparency and the reviewability of the work that we do. I know that there have been times years ago, it used to be just call up the judge and tell the judge, here's what I have. And some judges, I'm talking 20, 30 years ago, even some judges would say, okay, yeah, you have enough there. I'll sign the papers later, whether it's an emergency care order to take a child into custody. My view, and I believe the view of most judges, if not all, is that the work we're doing is important work that we need to have a record for the transparency so everyone knows what we based our decisions on. And so a circumstance with a law enforcement officer saying, I have the following 5 things, judge, can you give me permission to do X? If the judge says yes, and then that subsequently comes up for review, we have no record of what the judge reviewed. And that's why, for instance, even in situations where individuals are arrested after hours, a number of judges, myself included, I require the officer to submit the affidavit together with the requested conditions of release prior to making the decision on whether there is probable cause, what the conditions of release will be, and what the conditions of release will be, because the defendant and others need to understand what the judge was basing their decision on. And that transparency is something that I think builds respect for the system so that it's not this secret system that no one knows what the judge had, incapable of being reviewed. And so I think whatever would be designed would need to have a provision, much like search warrants. Because to remove that would open up the potential for abuses or even honest mistakes, but we need to do our best to make sure that that transparency is there.
And to follow up with that too, Judge, I think another thing to add is that, in the event, if let's say the exigent circumstance is put into policy, I mean, there is still accountability down the road. If it turns out that it wasn't actually exigent and the police officer was misusing that policy, I mean, that will come out presumably as the case is being litigated.
Well, what happens, the concern that I would have is, what if you have a judge, let's say 2 a.m, the judge gets a call and the officer says A, and the judge grants the order. And down the road, there's concerns about what the officer said, and the officer says, I never said that. And the judge says, yes, they did. Where are we? That's why we need a record. There needs to be a record so that we don't get into a he said, or he said, she said. We need to have a record of what the judge is basing their decision on under those circumstances.
So what I'm hearing, Judge, is that when you're talking about the record, you're talking about supporting the idea of having there be this inquest process so that there's a paper trail.
Yes.
Thank you.
And I do, as we're talking, I do think that there may be a way to come up with statutes that provide for this, that would allow for the after-hour circumstances. Think of the exigent circumstances where you may have an extremely serious crime that's being investigated. Law enforcement has to hold the scene and then apply for the warrant so that there is a capacity for review in the future. And that protects the rights of the individuals. It also makes sure that the system is not being utilized for improper purposes. And so I think we could design some type of statutory provisions or rules that could address the immediate need for law enforcement, provide a procedure for them to utilize. I don't know that there's going to be, again, significant usage. I think according to this, Mr. Luder's Dumont, and the testimony that I guess has been given by Sheriff Anderson, this is not something that it happens with a great deal of frequency. So I think we could, if I had some time to think about it, something tells me, and talk about it with other stakeholders, I think we might be able to come up with something that could address the need, but also, again, build in the protection for all involved.
Committee, any thoughts, questions? Senators?
I mean, that sounds like a solid spot to wait for the judge to give it some thought to come back to us with what would work to kind of meet the needs that. But I did have a question. I glanced over the petition list ceiling report, and I did have a question for you. And that is that report appears to be looking at if we were to move to sort of a broad petition list ceiling for all kinds of things. And I'm wondering how, and you don't have to answer right now, but I would love an answer at some point about how it would shift if we were only looking at petition lists. It would actually be expungement for things that are no longer crimes. Like, I would certainly support moving to a petition list system for more stuff, but that's not actually in this moment what's being discussed.
So I would first need to find, when you use the phrase "things that are no longer crimes," we would identify those. Then once we identify those, that can give us the number. And what I think would be reasonable is for us to analyze that like we did with the Act 167 marijuana. And that would give us the ability to assess the amount of work, because we know what it took for the marijuana and how long. And so, yes, I can try to find out. The question for me is, where's the identification of things that are no longer crimes? If you have any, if you're aware of any group or entity that has put together a list of crimes that would qualify there, that they would be thinking of, that would be helpful. I can do some looking on my end. I'm not sure that our data tracks it like that and says, okay, this conviction is no longer a crime.
Mm-hmm.
Marijuana, we knew that was a pretty big one, but I certainly can look into that. I understand
So
that.
I am interested in that aspect, the sort of retroactive, but I'm more interested actually in, and I realize I'm asking you to predict the future, in thinking forward. If we change a law and something becomes no longer a crime, those things are automatically expunged.
That one, I think, that one would be much in line with the marijuana.
Okay.
Marijuana was a large number, over 10,000, I believe. I could pop it up, but we had a large number. So to go prospectively, it depends on the number of cases. It could be something that's prospectively a couple hundred crimes, because there's some crimes that just aren't charged that much.
Right.
If it's a larger number, I'd have to know the crime to be able to really assess what the impact would be and what requirements would be on the judiciary.
Yeah, so thank you. I appreciate that. And I sort of assumed that that was going to be the answer. And like I said, I am interested in the information about retroactive. Like, in my ideal world, we would do both. But basically what I'm hoping for is that eventually we would deal with the retrospective stuff, but prospectively, that would just, what we did with marijuana would just be the standard if we eliminate crimes. And we wouldn't have to spell it out in every bill, like, oh, also, you have to expunge all these. It would just be the standard. Awesome, thank you.
Committee, any further thoughts, senators?
Yes, if I might, Director Dumont, I'm wrestling, I'm standing roadside here and I'm wrestling with Sheriff Anderson's example. And I realize that Jeb Soda can't give me advice, but that's why I'm referring this to you. I do not remember if the sheriff said that he thought the individual was a convicted felon or he knew the individual was a convicted felon, which now I'm getting two separate difference of advice from you as to how this works. I like the affidavit, the reasonable suspicion platform, and the criminal investigation portion of this. It's just a matter of how do we get there. So if I'm roadside and I stop someone who I think is a felon and I'm petitioning to, how would that rise to the level of I think. That's just, I don't have any knowledge or anything.
Yeah, so one of those things that Judge Downey was also a police officer at one point, but I won't put him on the spot. One of the things about reasonable suspicion, as you both know, as this committee has heard, is it's sort of a feel it. You kind of feel it when you see it. You see it when you feel it. You know it when you see it. And so in Sheriff Anderson's example, I can't remember whether it was a know or believe.
Right, that's what I came.
But because as officers are usually locally stationed, they know a lot of the community that they're interacting with. He could have had a reasonable suspicion that the individual was likely someone with a felony record based on his knowledge of the individual. I can't remember. I will reach out to him. But I think in terms of your understanding of the applicability of it, in terms of how you want to train the 80 law enforcement agencies in the state to understand one way that they can access sealed records in terms of the training, practice, and procedure. That's what I'm concerned about, because I also sit on the Criminal Justice Council where we eventually sometimes decertify officers. So I would want it to be very clear. So officers are trained as the reasonable suspicion. I like that. That's good. That's an existing standard. They understand what criminal justice purposes are. So now if you're connecting reasonable suspicion, criminal justice purposes, you kind of have two standards now. But at least we know what they are, and they're existing, and they're in statute and flushed out in some way in case law. And so roadside, you have reasonable suspicion that the person may have a felony record. That would be a reason to, because a person who has a felony record who possesses a firearm is a crime. So that you're not quite at PC yet, but you're almost there. It's the point just before probable cause. That's reasonable suspicion. So I think, I don't know if the committee is heading this way or not, but if you were to go a judicial path, it would want to be understandable, right? For all officers to know, okay, I got reasonable suspicion. This is a criminal justice purpose. I'm going to call the judge to make sure that I'm good, that I can use the record, for example, for the Monday arraignment, so the state can consider conditions of release for safety, for example. That type of, in terms of why and how we're using it, there's the access side, and now we're talking about the use side. So I like, it's a balance, and it's an existing standard scheme that I think we could easily train officers on in terms of applying. What we don't want is confusing multi-standards or confusing pathways where an officer would be unsure of how to proceed. But the examples that you've all heard in this committee, I think are helpful. Yeah.
If the committee would like, I certainly would take a closer look at this.
That would be great, yeah. Any additional thoughts or questions from the committee? Yeah, I mean, it's my own opinion to head in the direction of having this inquest process with the reasonable suspicion standard, while also having a path for exigent circumstances, which I think would be rare, but I do think it's something that needs to exist. Yeah, I mean, I don't need to provide any more examples. I think plenty have been described. And so I think that's my opinion. How do folks feel about generally moving in that direction? And then we'll wait to hear back from folks or from the judge and Tim about whether or not this is doable. Yeah. Great. Any further questions from the committee to witnesses or anything further from our witnesses?
Nothing further today. Thank you.
Great.
And they do instill that in you, because it's been a couple of days since I've been to the academy. They still give you the definition of reasonable suspicion.
Well, it's a tangible. I've heard someone say you feel it when you have reasonable suspicion. I'm right on the verge of PC.
Yeah.
Great. All right. I think we can go off.